Do complex legal issues hold you back? Let's get energized and bring clarity to your top legal questions. This is Law Talk with the Flock by Goosmann Law Firm.
Hello, I'm your host, Jeana Goosmann, a CEO, lawyer, author, and women business owner, here to help navigate you through the law, your business, and life as a leader. For today's episode, I have with me Sioux City Managing Partner, William Hale, and we're going to be talking about trade secrets and related trade secrets litigation. Welcome, Will.
Hi, Jeana.
Will, we've certainly worked on our fair share of trade secrets litigation together, haven't we?
We have, yeah, and they always seem to be pretty big cases too.
They sure do. So I think just so our listeners can get an idea, I thought we could start with just talking about what are trade secrets.
Absolutely. So trade secrets are that intangible knowledge that you have that you keep secret in your company, that if the information got out, another company could use it as a competitive advantage to try to hurt you or to try to increase their ability to compete in the marketplace.
You bet. And so let's talk about some examples of trade secrets. I think there's some obvious ones that tend to kind of come up. So who your customers are and what you charge your customers. So pricing information. Also who your suppliers are and your vendors and who you work with and how you work with them and what your terms are in those contracts. Perhaps also what you pay your employees and how you compensate your employees. Anything that relates back to how you actually make money in your business, I think can be considered a trade secret. And if it's not something that you're publicly sharing with others outside of your business and it's something you're keeping quiet, those have trade secret potentials around them. Metrics that you might be looking at. I know a lot of companies talk about key performance indicators. Also, some of your business strategy. What markets are you in? Where do you plan to go? Why do you plan to go there? Where do you think is a hot area coming up in your industry? Future casting, for example. So anything that you've done an analysis that would say, here's our 5-year strategy and our 5-year plan and where we plan to go. And if that's not something that you're publicly sharing as well. What other comments or thoughts do you have, Will, on what can be a trade secret?
Basically, it's anything that you gain a benefit of because your competitor does not know. So if it's something that helps you because they don't know that you're going to move into a particular area. They don't know that you're going to expand to a new market. They don't know that you are seeking certain types of customers. If it is beneficial to you that your competitors do not know those items, those have the potential to be a trade secret.
I also think of process and how you do what you do can also be a trade secret. So manufacturing tends to be something people think about right away as far as how do you do what you do. But I also think that can apply in a service business. How you deliver those services, how you decide, maybe it's what customers to take on. Is there a process that you go through when you're targeting new business? Is there particular marketing that you do? I know one time I worked with a client and one of their big secrets that they had in their industry was they did all this Facebook marketing and it was wildly successful for them. And they certainly didn't want any of their competitors to know that they made all this money from their Facebook ads. And it was a kind of a novel thing for that industry to be making a bunch of money from Facebook ads. So I think anything that is unique to how you are successful in your business can potentially be considered a trade secret.
Can even include potentially compilations of data. So if maybe it's common knowledge who's the customer of which company, but if you've gathered information about them and compiled all that data together, that could potentially also be a trade secret for your company.
I think that, we had a case and it was interesting where they were talking a lot about compilation, right? And it was a compilations case. And we heard a lot about that talk and really what does that mean? And there was some themes and theories about, well, it's a business in a box. And I think when you're getting into that territory, it's probably crucial to think about who at the company might have those level of trade secrets, right? It's probably not your frontline worker, or I always think of the bank teller. They're not necessarily going to know all the trade secrets of the bank itself, but who at the company is most likely to have the trade secrets, Will?
Absolutely. Those upper executives for sure are going to be likely to have those secrets. And as you were saying there, Gina, if it is something that even your most entry level employee knows, there's a chance that it's not a secret, because in order to keep it a trade secret, you have to actively take steps to keep that protected and keep it from being disclosed outside. So the more narrow group of people that have access to a certain amount of data, the more likely it's going to be found to be a secret. For example, the strategy discussions that happen in the board of directors, those strategy documents, if it's stuff that only the top level executives or the board of directors have, those could potentially be trade secrets. If it's something where you're getting ready to do a public announcement and you've already told all of your frontline employees that you're going to be doing something, it's going to be less likely to be a trade secret at that point, because of the lack of secrecy that is shroud around it.
Absolutely. So it can depend, like a lot of things in the law, right? As far as who holds your trade secrets, and they might not necessarily just be your C-suite folks. Although a lot of times, the higher level of the employee, the more that they tend to have those secret sauces or the trade secrets of the company. But even if I went back to that marketing example, if that company that had the person placing all those Facebook ads, they had that secret in their hands, right? That was something that was so valuable to them that they certainly didn't want their competitors to know. And so it just depends on who might have those secrets. But let's not talk about how companies can go about trying to protect them. What are some steps that they can take for protection?
Absolutely. You got to take what the law would call reasonable steps to protect it. And that can be having NDAs or non disclosure agreements signed by people who have access to certain data. It can be, first of all, limiting who has it, using IT resources, password protected, limited access locations in your network drives that only certain individuals have, and making sure to keep that information there. Because the first step in protecting your trade secrets is to making sure they don't leak. Because once they've leaked, then it becomes harder and you're less protecting it, and you're more trying to get it back or to prevent its further use. So those type of protections and limiting access are going to be key.
So limiting access, I think company policies and process and procedure, a lot goes a long way here when it comes to those protections. I know highly recommend people have confidentiality agreements signed with their employees when they onboard them. And you could reference trade secrets in those confidentiality agreements, and perhaps a listing of what some of those would be for your company. And then I loved how you talked about in the IT settings, making sure you kind of limit access to who gets what information. Really good thoughts and tips there.
It's also a good recommendation to make sure you label things that are supposed to be kept confidential, so that way employees don't accidentally spread them out farther in the organization than you want them to be. So if it is something like, for example, your board deck that you're going to be using, not a bad idea to throw on there that it's confidential, and that could potentially be a secret.
You bet. It's a lot harder for somebody to say, I didn't know that was confidential, if it's actually labeled confidential.
Absolutely.
So now let's get into the area of, so we've got these trade secrets that are valuable to a company. And I think some of the fact patterns that we see where it ends up in litigation. I know the number one fact pattern that I tend to get over and over and over is where you have some employees, often they're key employees, and they leave and they either go to a competitor or they leave and they start up their own shop. That tends to result in a lot of trade secret litigation. And sometimes in those instances as well, those employees are, when they're preparing to leave, they do things like document, take files and download them, email themselves to their personal account. And when they're doing that, because they're preparing to compete, that's when they tend to actually be stealing from the company the trade secrets. And that tends to lead to litigation later, doesn't it, Will?
It does. And probably most of the cases I've seen, trade secret litigation comes up when somebody has left, because if somebody is still there and leaking your secrets, they're probably not going to be there very long. So you're absolutely right. It happens when people are leaving to a competitor. They will often beforehand insert USB drives and download a bunch of documents to their to their drive and take with them, or they'll email themselves. And it's important to check for those if you have a key employee who's left and you suspect that they may be then using that information someplace else.
That's a great point. So I think when a company has one of those things happen, it's probably a great time to call your lawyer. As far as, hey, I have this employee, they're leaving going to a competitor, or this employee and they're leaving and they're going to compete with us now. We often are able to come in and advise them at that point in time and give them some great ways to protect the business and to monitor and watch. And we work hand in hand with the forensic IT folks to also help make sure that we're protecting the business in that process. It's also a good time you could send a reminder to that exiting employee, reminding them that they signed these confidentiality agreements, or that trade secrets law exists, and you want to make sure that they don't take anything with them that would harm the business down the road.
Absolutely.
And what about when they, everything gets a little nasty? Because I usually tend to think it's when that first big account gets called, or that supplier is now going to be shifting and working with that competitive company. But there's some sort of competitive activity that's happened, and now all of a sudden we end up in a battle. Talk to me about what those battles look like, Will.
Yeah, those battles often get very lengthy and very time and fact intensive. It often starts with a lawsuit getting filed against the departed employee, oftentimes even including the company that the departed employee has gone to, um, especially if that company knows or should know that this employee is taking secrets with them. They can also be held liable. And so as the case progresses, there's a lot of tech that is used. You have to work with the IT folks, the forensic IT, to uh, take a look and see what information maybe was removed from the company devices prior to their departure.
Yeah, and I think often too these cases kind of go hand in hand with non-competes, but people don't have to have a non-compete in order to have a trade secret case, do they? Will?
No, they don't. A non-compete is a good thing to add on there to the lawsuit if you have one in place. But even without a non-compete, or even without a set confidentiality agreement, trade secret law still exists there that can protect it. Having a confidentiality agreement is one piece of trying to protect the secrets. But if you're doing other things that are sufficient to try to protect those secrets, even if they never signed an agreement like that, you could still go after them and try to hold them liable for taking or misappropriating those trade secrets.
Now we work both sides of these cases. We kind of are talking like we're just working on the side that's going after folks for taking the trade secrets, but we also heavily work on the defense side of these cases. So if you are the startup company or you are the competitive company, you want to hire key talent because there's limited talent in the marketplace. There are also some things you can do to defend yourself and to make sure that you are set up for success when you're hiring that competitive employee. And I think one of the best things to do there is to make sure that they know you don't want them to bring information from the other company with them. And to the extent that they have done any of those activities, that actually jeopardizes their employment with you at your business. Because if you have that USB drive or that hard drive connected to your system, and now all of a sudden you're commingling the data in any way, shape, or form, or you're using their form or their template or their process, now that it exposes you to liability. So as far as trying to document that you have made sure that you've advised that employee that you don't want that information, and having company policies as well that say to your employees, don't do that.
Absolutely. And it's also good to make sure you keep a good record of where you are getting some of that information. If there is information out there that people might think is a trade secret of another company. If you're getting it from a public source, make sure you keep record and document where it's coming from. So that way, if the lawsuit does come, you can show that, no, we did not get it from this improper source, but we got it from this publicly available source, or we developed this information on our own. You want to have good record of that information.
You bet. And one other thing I was just coming on is there are federal trade secret laws that cover the whole United States. And then there are also different state-specific trade secret laws. And sometimes they mirror the federal law, but there might be different nuances in them. So good things to think about both on the federal level as well as the particular state.
Absolutely. Especially if you're a company that operates in more than one state, it's good to have become familiar with the trade secret laws in each of the states in case there are some key differences as to maybe what you have to do to protect the information or what you can do if a former employee is misappropriating it.
Awesome. Well, thank you so much for joining me today, Will. Have a great day, everyone. Go make it worth it. Goodbye.
Thanks for joining us for Law Talk with the Flock by Goosmann Law Firm. We hope you feel energized and ready to soar past your goals. Become a Flock fan and subscribe to our podcast for weekly episodes. Learn more at goosmannlaw.com.